Good morning to everybody, and this is my second in absentia students class. I told my students whenever you are free at any time, you may join with the Cisco WebEx so that you could see what I posted on the screen and you may read it. If possible, you can explain. In case you fail to do so, I will come to the rescue. So both the way, it is one point touch to another point touch. That means from reader to or from the resource person to the listener and the listener to the resource person. So without wasting time, let me pounce upon the part. I believe this is the fourth or fifth series, if I not be mistaken. The topic is, what is the difference between IHL, that means International Human Rights Law, and Human Rights Law. Both IHL and human rights strive to protect the lives, the health, and the dignity of individuals. I repeat, both IHL and human rights law strives to protect the lives, the health, and the dignity of individuals. What is the International Human Rights Law? Human rights law is a set of international rules. I repeat, human rights law is a set of international rules established by a treaty or custom on the basis of which individuals and groups can expect and or claim certain rights that must be respected and protected by their states where they are the subjects. The body of the International Human Rights Standard also contains numerous non-treaty based principles and guidelines. Of course, that's why they will say it's a soft law. Then we come to the matter of the main treaties. The main treaties of human rights are given below. A. Universal instruments. There you can come across conventions on the prevention or the punishment of crimes of genocide, 1948. Next, conventions on the elimination of all forms of racial discrimination, 1965. Number third, International Covenant on Civil and Political Rights, 1966. Next, International Covenant on Economic and Social and Cultural Rights, 1966. Then comes Conventions on the Elimination of All Forms of Discrimination Against the Women, 1979. Conventions against torture and other cruel, inhuman, or degrading treatment of punishment, 1984. Suppose if you would be participating in my class, I would definitely ask you, read the next point from here, which I am showing the cursor. But to my knowledge or to my bad luck, even though I have specified the time, but you have not come across it. I doubt which I loaded yesterday, you might have seen it or not. Let us come to the point. Sooner or later, you will get the benefit of my lectures. Next is Conventions on the Rights of the Child, 1989. Next, International Conventions on the International Conventions on the Protection of the Rights of All Migrant Workers and Members of their Families, 1999. International Convention for the Protection of All Persons from the Enforced Disappearance, 2006. Conventions on the Rights of the Person with Disabilities, 2006. The B category, there is the regional instruments. Of course, we are dealing with the international, but anyway, the chance has come. Let me throw a light on the regional instruments also. Number one, European Conventions on Human Rights, 1950. Number two, American Convention on the Human Rights, 1969. Number three, African Charter on Human Rights, Women and People Rights 1981. These treaties are supervised by the human rights bodies, such as the Human Rights Committee for the International Covenant on Civil and Political Rights and the European Court for the Human Rights for the European Convention on the Human Rights, while IHL, International Human Rights Law, and the Human Rights Law have developed their separate ways. Some human rights treaties include the provision that comes from the HIHL. For instance, the Convention on the Right of the Child and its optional protocol on the involvement of the children in armed conflict, and the Convention on the Enforced Disappearance. It comes in the IHR. And IHL, yes. Come to the IHL next. IHL and International Human Rights Law are complementary bodies of the international law. There are some of the same aims, but both IHL and the human rights law strive to protect the lives, the health, the dignity of the individuals, albeit from the different angles, which is why, while very different in formulation, the essence of some of the rules is similar. For example, both IHL and human rights have prohibited torture or cruel treatment, prescribe basic rights for persons subject to criminal process, prohibit discrimination, contain provisions for the protection of women and children, and the regulated aspect of the right to food and health. There are, however, important differences between them, their origin, the scope of their application, the body that implement them, and so on. So if you would participate at least online, I would have to ask you to read from the origin, so that you could participate it. Then I would like to ask the questions to you, so that would be cause face-to-face class, even though we are not in face-to-face. Let us see that origin. IHL, that is International Human Rights Law, the origin of which are ancient, was codified in the second half of the 19th century under the influence of Henry Dunant, the founding father of the International Committee of the Red Cross. See question 6 in the reference. Human rights law is more recent body of law. It had its origin in certain national human rights declarations influenced by the ideas of the Enlightenment, such as the States Declaration of the Independence in 1776 and the French Declaration on the Rights of Man and the Citizens in 1789. It is only after the Second World War that human rights emerged under the auspices of the United Nations and the branch of the international law. The Universal Declaration of Human Rights of 1948 first defined human rights law at the international level in a non-binding General Assembly resolution. It was only in 1966 that this declaration was translated into Universal Human Rights Treaties. The International Covenants on the Civil and Political Rights and the International Covenants on the Economic, Social and Cultural Rights, both of 1966. The temporal scope of application, what it means. While IHL applies exclusively in armed conflict, human rights law applies in principle at all times. In a peacetime, during armed conflict, however, unlike the IHL, some rights treaties permit government to derogate from the certain obligations during public emergency that threatens the life of the nation. Of course, we will make a debate how it can be treaties, what is must, what is not must in the discussion. The derogation must, however, be necessary and proportional to the crisis, and must not be introduced on a discriminatory basis, and must not contravene other rules of international law, including provisions of IHL. Certain human rights can never be derogated from. Among them, the right to life. I repeat, among them, the right to life, the prohibition against the torture or cruel, inhuman, or degrading treatment or punishment, the prohibition against the slavery and servitude, and the prohibition against the retroactive criminal laws. Let us see that geographical scope of application. Another major difference between the IHL and the human rights law is their extraterritorial reach. That IHL governing the international armed conflict applies extraordinarily in not a subject of controversy. Even that is the purpose is to regulate the conduct of one or more states involved in an armed conflict on the territory of another. The same reasoning applies in non-international armed conflicts with an extraterritorial element. The parties such conflicts can't be observed for their IHL obligations when the conflict reaches beyond the territory of a single state. Despite the view of the few important dissenters, it is widely accepted that human rights law applies extraterritorially based inter alia on decisions by the regional and international courts. The practice, extent of which application, however, is to be determined. Human rights bodies generally admit the extraterritorial application of the human rights law when a state exercises control over the territory. There is the occupation of a present. That is a definition, we can make it out. Then comes later, human rights case law is unsettled. I repeat, human rights case law is unsettled. However, on the extraterritorial application of the human rights norms governing the use of force. Next subheading, personal scope of application. Suppose if you are present over there, any one of them, I would have like to ask you to read this one, but I found in your absence, that's why I'm continuing. IHL aims to protect the persons who are no longer taking direct part in the hostilities. It protects civilians and combatants, first-day combat, such as the wounded, the sick, or the shipwrecked, prisoners of war. Human rights law, developed primarily for the peacetime, applies to all persons within the jurisdiction of a state. Unlike IHL, it does not distinguish between the combatant and the civilian to provide for categories of the protected person. Next, we'll see protected. Yes, parties bound. Yeah, civil provided the categories of the person protects. Parties bound by the IHL and human rights law. IHL binds all parties to an armed conflict and thus established an inequality of right and obligations between the states, on the states for the benefit of the everyone who may be affected by their conduct and essentially original relations. The human rights law splits governs the relationship between state and persons who are in its territory and are subject to the jurisdiction, and essentially a vertical relationship, laying out the obligation state vis-a-vis individual across a wide spectrum of conduct. Thus, human rights law binds only states as evidenced by the fact that the human rights treaties and other sources of human rights standards don't create a legal obligation for non-state armed groups. The reason for this is the most group of this kind are unable to comply with the full range of obligations under human rights law because under the governments they cannot carry out the function on which the implementers of human rights norm is premised. There is a notable exception to this generalizations about the non-state armed groups. Those cases in which a group, usually with the virtue of the control, stable control of the territory, has the ability to act like the state authority and weights human rights responsibility, therefore be recognized de facto. The substantive scope of application. IHL and the human rights law shares common substantive law which such as prohibition of torture, but they also contain very different provisions. IHL deals with many issues that are outside the purview of the human rights law, such as the status of the combatants and the prisoners of war, the production of the Red Cross and the Red Crescent emblems, and the legality of the specific kinds of weapons. Similarly, human rights law deals with the aspect of life that are not regulated by the IHL. I repeat, similarly, human rights law deal with the aspect of life that are not regulated by the IHL, such as the freedom of the press, the right to assembly, to vote, to strike, and other matters. Furthermore, there are areas that are governed by both the IHL and the human rights law, but the different and sometimes contradictory way. This is especially the case of the use of force of detention. Yes, next. Regarding the use of the force, IHL refers to an conduct of the hostilities recognized for the use of the lethal force inherent to waging war. This is because the ultimate aim of military operation is to prevail over the enemy's armed forces. Parties to an armed conflict are thus permitted, or at least are not legally barred from, attacking each other's military objectives, including enemy personnel. Violence detected against the target is not prohibited 40 by the IHL, regardless of whether it is inflicted by the state or non-state party to an armed conflict. Acts of the violence against the civilian and the civilian objects, as well as the indiscriminate attacks, are by the contrast unlawful because one of the main purpose of the IHL is to spare civilian and civilian objects with the effect hostility, and IHL prosecution must be taken into in order to minimize the civilian losses. Human rights was covered. I repeat, where you missed it. Civilian precaution must be taken in order to minimize the civilian losses. Human rights was conceived to protect the person from the abuse of the state. It regulates not the conduct of the hostilities between the parties to a conflict, but the manner in which force may be used in law enforcement. The law enforcement is predicated upon a capture rather than the kill approach. The use of force must be last resort for the protecting the life. When other means are ineffective or without promise of achieving the intended result, and must be strictly proportionate to the legitimate aim to the achieved to prevent crime, to effect or assist in the lawful arrest of the offender or suspected offender, and no maintain public order and security. Concerning the detention, while both the IHL and the human rights provides for rules on the human treatment, detains and detention conditions and the fair trial rights, difference emerge when it comes to the procedural safeguards in internment. That is a non-criminal intention of a party based on the seriousness of the threat that is not prohibited during the armed conflict, and in general, a judicial of the lawfulness of the detention is not required under the IHL. Then let you go further outside the armed conflict, non-criminal, within parenthesis administrative detention is highly unusual. In the vast majority of the people are deprived of their liberty because they are the vast majority of the cases. People are deprived of their liberty because they are suspected of having been committed a criminal offense. The international covenant of the civil and political rights guarantees to the liberty of the persons and provides the every individual who has been detained for whatever the reason has a right to judicial review with the helpfulness of her detention. This area of human rights lies based on assumption that courts are functioning. The judicial system is capable of observing all persons arrested at any given time, regardless of their numbers, to perform their task, etc. Circumstances are very different during armed conflict, which is reflected in the provisions of the IHL. Then you would have to present over there, then actually I would like to ask to read. But your absence is there, then I am continuing. The interplay of the IHL are the human rights rules governing the use of the force, procedural safeguards for the internment, at least in international armed conflict, must be resolved by reference to the lex specialis. That is the provision of the IHL that were specifically designed to deal with those two areas. Now let us see that the interplay of the HAL and the human rights law. The interplay of the IHL and the human rights law remains the subject of much legal attention, particularly because of its consequences of the conduct of the military operations. In its every statement on the application of the human rights, Situations on Conflict 1996, advisory opinion on the legality of the threat or use of the nuclear weapons, the International Court of Justice observed that the protection provided by the International Covenant on Civil and Political Rights did not cease in times of war, and that, in principle, the right not to be arbitrarily deprived of one's life applied also in hostility. The court added that, I repeat, the court added that was constituted arbitrarily deprivation of life had led to the determined by the applicable lex specialis, namely the law applicable in armed conflict, which is designed to regulate the conduct of hostilities. This statement has generally been interpreted as settling the issue of the interplay IHL and the human rights law, is implying that human rights law deemed applied to all times constitute the lex generalis, while IHL, whose application is triggered by the occurrence of the armed conflict, constitute the lex specialis. That's the difference that we can make it out. IHL will be triggered by the armed conflict. In other words, when human rights law and IHL are in conflict, the latter is deemed to prevail. That means IHL will prevail, since it was considered specifically to deal with the armed conflict. While the meaning and even the utility of the doctrine of lex specialis have been called into question, there is a general acceptance of the interdisciplinary of determining the interplay of the IHL and human rights law. Although generally speaking, those two branches of international law are complementary, the notion of the complementary can't resolve the intricate legal issues of the interplay and sometimes arise. In some instances, IHL and human rights rule might produce conflicting results when applied to the same facts because they reflect the different circumstances which they were primarily developed. So, because of the students are not present over there, in spite of my repetition, that when you would be available, so that I would conduct the class, but only once in a week you are coming. By the time the power is not there, if any untoward incidents happens. Of course, on the time also we'll conduct the direct face-to-face class on the Cisco WebEx, where we can read and you can give the reply and we'll make it the things. So with this, I would like to wind up of my today's lecture. So thank you very much for patience listening, and end of the meeting.